situation where, well, you've heard me say it before, we've had the rug pulled out from underneath us, and getting to the bottom of the ins and outs of that is hard too.
Hey, Glenn, honey, can you mute when she's talking? Otherwise, we hear feedback.
Well, it's probably because I'm open. I got my petition for writ of certiorari filed today.
Awesome. That's good news.
It's in the mail. It's in the mail. Let me put it that way. But I don't know if we want to go through that. It's the final one that was sent in.
Nice. Well, that was the one that you went over last week, so you can point out all.
Is that what we went over last week?
Yeah. Well, you were working on it. So.
Yeah. Right. Yeah. Well, and so I finished it, and I had to make 10 copies, and then I went and I didn't send the impecuniosity thing. I sent a little 1-page letter, basically. So we can look at the letter anyways. But yeah, it's 328 pages, the whole thing. And
the index.
Right, with the index, the table of authorities. I had to make a table of authorities, and table of contents. That's all required by the rules, and yeah, it's all, yeah. Anyways, we can go through that or parts of it. I don't know what else.
Big accomplishment, though. That's a big accomplishment.
Well, I'm glad
that I feel good. That's a big accomplishment.
Yeah, I'm glad I got it in. It's been something a little, it's been a little bee in my bonnet, basically, where it's been bugging me. And so I'm glad I got it in. Now, that doesn't mean they're going to accept it. They could send it back. Matter of fact, a lot of times they do, and say, well, you didn't do this and you didn't do that. But I've done this. This is number 6. So I'm getting it down. And so we'll see.
Yeah. And all the rest were struck down. Say that.
Sorry?
Well, you've had success with all the rest.
Well, I got the same kind of rulings. This one is, I'm not doing the affidavit of impecuniosity. I'm doing it a little bit differently this time. So we can go through what I did. But I do explain in the petition that I am posterity, and they don't have any authority for anything, basically. That they're a legislative court, an inferior court, and our one Supreme Court is a common law court. And anyway, so we'll see. Bureaucrats.
Okay, well, it looks like Queen started the recording for us and changed the title. So do you want me to read the Bivens and we can get on with it?
I will, what I will do is I could probably upload the whole thing to the group. I'm not sure. But I will upload the Word files. I'm doing the Word files right now while we talk. And so the Word files are being uploaded to the to my page on the group, and they're uploaded now. I don't know. Is there a limit as far as Queen's concerned, as far as how big the files can be?
Not that I'm aware of, Queen.
Okay. Well, let's see.
I don't know. There's some pretty big files uploaded.
Okay. Well, I'll upload the whole thing, and we'll see what happens. It's here.
And Glenn, just FYI for your information, if you are talking, leave your mic open. But when you stop talking and you're looking for responses or feedback, if you mute your mic, the recording will be.
And so I gotta mute it when I'm not talking. So I appreciate the input, and I might need to be reminded too.
That's okay, brother. Yeah, I just want to let you know.
Okay, so it is uploading right now. The tertiary, it's 140 megabytes. That's the whole file. It's a PDF of the whole thing. It's uploading right now. Anyways, I what I'll do is, I don't know if you want to go through the thing. We can breeze through. Is there anything else that we want to do tonight? I really didn't have anything else to talk about, but I can go through, how I put it all together, and we don't necessarily have to read the whole tertiary, but I can have it on the screen and share it and go through what I did.
Yeah, it's always really good to see how the signing always happens and how the layout occurs. And I don't think anybody has seen the full package of one of these going off and how large they can actually get to. So I would appreciate it.
Okay. Okay, so there it is right there. I'm just going to.
Want me to do Bevins?
Yeah.
Okay, gotcha. Here it is. This meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums. Can you mute up, Glenn, please? Forbidden and shall be addressed in appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, county, city, township agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, state your name, and state your position. Number 2, this meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of the federal, state, county, city, township agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. One last time. This meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of the federal, state, county, city, township agency present? Good. This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. Looks like we're all clear, and I'll open up our meeting with a short prayer. Holy Father, please bless our meeting, or bless our meeting with eyes to see and ears to hear the messages that and info being presented, with an open, caring, and compassionate heart for all our fellow brother and sisters, as it shall be done. Take it away, Glenn.
Okay, well, if you read the rules, there's actually two different ways you can do it. One of them is kind of technical, and this is the easy one. And so this is the one I always do. But there's actually two ways you can do it. So this is the cover sheet. This is a petition. It has to be signed on the front page like this. And then there's a table of contents. All of this is required. It has to have a table of contents, and it has to have, if you look here, these major categories: contents, table of authorities, questions for review, summary of the case, statement of jurisdiction, constitutional, statutory, and then statement of the case, conclusion, and appendix. Those are all listed in the rules. That all of those have to be there. The appendix is optional, and so the table of authorities. That's one of the things they say in the rules, is that if you have something like one of these sites, if it's listed a whole bunch of times, if you do it with the automatic, you can actually set it up to do this in Word automatically. But if you do it, sometimes the Word will make it put PASSIM, PASSIM there, which means that it's listed there a bunch of times. And and it says in the rules, don't do that. And so I manually went through and put these all in here. It's all done manually. It's a major pain in the butt, but that way it's done right. And so there's 5 pages of authorities, and then the table of contents, the table of authorities, the questions for review are not included in the page count. Okay, so you're allowed 40 pages, and it's not included. This stuff isn't included in the page count. So anyway, so there's the questions for review. So notice I numbered the page numbers, and I numbered them differently for in this front matter. This is, you might call, the front matter of the petition. It's numbered differently. So there's actually 2 or 3 files, matter of fact, I uploaded about 8 different files to the group. And we're going to talk on, and all of them put together become this, except for there's a certificate of service and and a clerk's letter that we're going to talk about separately. But these are the questions that I made, that I asked. Is the 1871 Municipal Corporation at 12 Stat 419 unconstitutional violation of Article 1 and Amendment because it comes from what is now the Vatican? And then is the minor estate an unconstitutional violation of Article 1 Amendment because it was created by the Pope's Crown of England with the Sestacavi Act of 1666 and brought into America with a code of law for the District of Columbia in 1901 at 31 Stat 1432. What I did was 17 is a really important number, so I made 17 questions. That's a Masonic number. Ruth, the book of Ruth in the Bible is the 17th book, and so there's 17 is a really important number according to the Illuminati, I guess you might say. Anyways, this is the National Bar Foundation, all its subsidiaries in the various states, an unconstitutional violation of Article 1 and Amendment, because it is the Pope's private bar guild originating in the Pope's owned and operated city of London, claiming immunity under the International Organization Immunities Act of 1945. Is it an unconstitutional violation of Article 1, Section 8, Clause 17 to use the minor estate to convert the petitioner's land from the land of Texas into the foreign District of Columbia? Is it an unconstitutional violation of the Equal Protection Clause, Article 4, Section 2, Clause 1, for the FBI to refuse to investigate felonies by the County of Montague Municipal Corporation to assault the petitioner with the minor estate, to justify the theft of the petitioner's land, to get fake money in support of the communist agenda to eliminate private property rights, and because the petitioner is a targeted individual, as evidenced by the targetedjustice.com website. Is a judgment by the 97th District Court that makes the petitioner a minor estate a bill of pains and penalties? Is a judgment by the 97th District Court that makes a petitioner a minor estate a denial of due process under Article 5 an amendment by presuming incapacity without adjudication? Some of this stuff was actually a friend of mine did a Grok AI search on some of my questions, and this is what some of it came up from that. And so I figured, oh, those are interesting questions. I think I'll put those in. Anyway, so is the this one about this by presuming incapacity without adjudication is one of them that Grok came up with. Is a judgment by the Northern District, Texas, that makes the petitioner a minor estate a bill of pains and penalties. Is a judgment by the Northern District of Texas that makes the petitioner a minor estate a denial of due process under Article 5 an amendment by presuming incapacity without adjudication. Is the refusal by the FBI to investigate the 78 criminal complaints a denial of due process under Article 5 an amendment? Is the refusal by the U.S. Attorney to prosecute the 78 criminal complaints a denial of due process under Article 5 an amendment? And the reason I call it is I don't say the Fifth Amendment. It's really called Article 5 an amendment. And so you have to make sure and call it the proper thing. Is it a violation of the Equal Protection Clause, Article 4, Section 2, Clause 1, for the U.S. Attorney to refuse to prosecute the felonies by the Montague County Municipal Corporation to assault the petitioner with the minor estate, to justify the theft of the petitioner's land and their extortion racket, to get fake money in support of their communist agenda to eliminate private property rights, and because the petitioner is a targeted individual, as evidenced by the targetedjustice.com website? Yeah, that was really wordy and long, and some of them I was thinking about shortening, and that's probably one I should have. But at any rate, is it an unconstitutional violation of the Equal Protection Clause, Article 4, Section 2, Clause 1, for the Comptroller of the Texas to authorize the County of Montague Municipal Corporation to assault the petitioner with a minor estate and render by force the petitioner's land for taxation, to justify the theft of the petitioner's land, to get fake money in support of their communist agenda to eliminate private property rights, and because the petitioner is a targeted individual, as evidenced by the Targeted Justice website? Is the findings, conclusions, and recommendations of the magistrate judge that fails to be a findings of fact and conclusions of law, a legislative usurpation of the bench, because it's involving a fiction of law which fails to exist under the Pope's ecclesiastical law, penalizing the petitioner and named individual with a non-judicial theft of land and a bill of pains and penalties violation of Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. Is the findings, conclusions, and recommendations of the United States magistrate judge which fails to be a findings of facts and conclusions of law? It says findings, conclusions, and recommendations. Does it say finding of fact? Matter of fact, that's one of the arguments in there that I say in there, is it has nothing to do with facts or law. Anyways, a denial of due process of law in violation of Article 5 of an amendment. Is the findings, conclusions, and recommendations by the United States magistrate judge that fails to be a finding of fact and conclusion of law a violation of the Equal Protection Clause under Article 4, Section 2, Clause 1? Is using the Pope's minor estate and the Commerce Clause, Article 1, Section 8, Clause 3, constitutional to violate Article 1, Section 8, Clause 17, a maximum of 10 miles square? So anyways, so then it goes into the case. Now, we have already read this. We did it last week, so I'm not really going to go through this. We already went through that last week. So that's...
Can you answer a question?
Sorry?
Would you answer a question about that website? How did you find out about that website?
Oh, I don't know, but it certainly talks about targeted justice. I don't know. Somebody sent it to me or something. Stuff just lands in my lap. I'm telling you. Go to the website. You'll see that it's talking about the kind of stuff that's happening to people all the time. And it talks about it. It has actually affidavits by former FBI. What was his name? He's dead now. He was in charge of the LA Olympics for the FBI. And
not Ted Gunderson.
Yeah, Ted Gunderson. Yeah. Anyways, that he says that this is the stuff the FBI does. Anyways, don't get me going. Anyways, so we'll just breeze through this. So there's 40 pages. You're limited to 40 pages on this thing. And so there's page 40. That's the last one. And so then the way you get around that is you attach an appendix. And that's where you attach evidence. Okay? And you have to reference this stuff. You talk about it in there in the petition itself. Like, for example, if you go back here, get past the questions, summary of the case, right here. So I converted silver to land in 2021. True copy of which is attached to the notice of objection to the findings and conclusions of the magistrate judge in motion to reconsider, so which is attached here to in the appendix. Okay, so I'm referencing the forced rendition is with this taxable property form, Texas taxable property form, which is attached to the notice of objections in the appendix. So I'm talking about this stuff that I sent to Catherine Phillips notice and demand, which is attached to the notice of objection that's attached in the appendix. So I'm talking about all that stuff, and the tax suit that they filed against me, and the 78 criminal complaints, which is talked as evidence by the demand to disqualify the judge, and that's in the appendix. And I filed a writ of mandamus in the Second Court of Appeals, and they went and refused to accept the filing because I'm a vexatious litigant, and that's in the appendix. Anyway, so I reference all this stuff. So let's go back to the appendix now. Here we go. Now, the appendix has to have a table of contents, so I had to make a table of contents for the appendix, and this is what it is. So I put tabs on there, and it can get quite expensive. So I went and you can buy these little self-adhesive tabs that you put on a piece of paper, and that makes it a lot less expensive. And the Court of Appeals accepted it, no problem. And there's really, in the Court of Appeals, it said that it had to have tabs. But in the Supreme Court, it didn't say anything about having tabs. And so I didn't really have to put them in there, but I did just because it makes it easier to go through it. Anyway, so there's a demand to disqualify the judge, and I went and I hand numbered the bottom of the page. And that's not really required if I remember correctly, but I do that just to kind of tie it all together. And I talk about it in the table of contents, Second Court of Appeals, vexatious litigant letters, the findings, conclusions, and recommendations of the United States Magistrate Judge, the notice of objection that I filed, the order accepting the findings, conclusions, the final judgment, the notice of appeal, the notice of constitutional challenge. So under the rules, if you're going to challenge the constitutionality of something, you have to file a notice of constitutional challenge. And I didn't file that until after the case was over, but I don't think that's a problem. And I'll bet you nobody complains about it. Anyways, mandatory judicial notice of 12 presumptions, the affidavit of life, notice of void judgment, I'm an in-your-face sort of guy. So I went and filed this right into the case, and I said these judges are clerks, they're Pope's clergy, and I filed it right into the case. I'm sure, and I know those judges saw it. Affidavit of finding of facts, that's the common law court judgment, okay? And so I want to see what the courts say about that affidavit of finding of facts. I don't think that they can say anything, okay? That's common law. They haven't got a word to say about common law. All they can do is affirm it, okay? Under the Seventh Amendment, it says that anything done by common law can only be reviewed by the rules of common law. And none of the courts operate under common law. And so they're kind of screwed. And so all they can do is affirm it, is recognize it. You see what I'm saying? So we'll see what they say about that affidavit of finding of facts. So anyways, that's the, and then what I do is I put a cover sheet, which each document. So there's the cover sheet, and then I have those self-adhesive tabs that I put on there, and that's tab 1. And so then this is the demand to disqualify the judge. This was the first judge, and so it's listing 78 criminal complaints were filed into the case on or about the 27th day of February 2023 and on or about the 14th day of March 2023. True copies of the certificates of service are attached here to all of which are incorporated herein by reference in their entirety. Your Texas Code of Criminal Procedure, Article 15.09, requires a warrant to be issued. The issuance of warrants fails to be discretionary and is a ministerial duty and mandatory for any magistrate. Please find attached a copy of the court's oath of office and anti-bribery statement as provided by the Secretary of State. The judges failed to issue warrants for the arrest of those named in the criminal complaints, which is a breach of trust, perjury of oath, and demonstrate that the judge fails to be neutral and unbiased, is actually bought and paid for, and fraud upon the court exists. And so, and that was it. And that judge actually recused himself. And this is the certificate of service. And there was violating rights, official oppression. That's a Texas Class A misdemeanor. Violating rights and immunities under color of law. That's a felony, U.S. felony, federal felony. Conspiracy to threaten, coerce, injure, intimidate, and the free exercise of rights under color of law. That's a federal felony. Perjury of oath. Tampering with a government record. False entries in government records. Those are all like felonies, and those are actually federal felonies. Sale into involuntary servitude and peonage, tampering with a government record, obstructing by force the free exercise of religious beliefs. Yeah, so I sent those, and then this is the second batch. Extortion racket, barratry by the lawyers, false entries on and reports of money and securities, theft, unlawful appropriation. So what I'm hoping happens, quite frankly, and I wouldn't be surprised, is if the Supreme Court orders the FBI to go down there and fucking arrest them sons of bitches. So we'll see. That's all I can say. I'm not sure. You know what? I'd be surprised if the court would actually order him to do. I wouldn't be surprised, though, if somebody from the court made a phone call to Cash Patel, and then Cash Patel fucking shit rolls downhill. You see what I'm saying? But so, anyways, I have no idea. I have no idea. I can't possibly say what's going to happen, but that's what I'm hoping happens. Anyways.
Well, you've got number 17 involved, so.
Sorry?
You got number 17 involved.
17? Yes, that's right, in the questions. So that's.
But no, that must be like 3.5 inches thick, eh?
No. No, actually, in the rules, it says it has to be printed on two sides. So all of this stuff is two-side printed. In the up here, we're in the table of right here. Yeah, the tabs, these are printed on one side. This is printed on one side. This is printed on one side, because I put the tab there. But this other stuff, this is printed two sides. And that's 11 pages, so it's only really about 5 pages. Yeah, so one staple, one big staple, I have a monster stapler. And so it does, so the whole, it's 350 pages, 328 pages, but when it's printed on two sides, it's only like about 100 and, it's, maybe 100 and, it's still about an inch thick. It's probably about an inch thick. Yeah. I made some extra copies, but, so this is the, demand to disqualify the judge. And that judge stepped aside. See, there's I sent it by certified mail. And then the Second Court of Appeals corks vexatious litigant letters. And I wouldn't be surprised to have someone in somebody, I bet you that clerk will resign. I bet you that clerk will decide to retire. Who knows what? I'll bet you that's what will happen. Something shit will happen. I guarantee you. Because this
Glenn, can you take a question from Dan? He's got his hand up.
Sure, I'm going to mute myself, then you can ask.
Go ahead, Dan.
I just wanted to congratulate you, Glenn, because you're one of the few people that are like me. Thank you.
Okay.
Well, he gave me shit about something that I just saw, so can I ask a question now?
Go ahead, Lori. What's up?
So when I wrote out my affidavit and didn't put in the beautiful page numbers, and I replied back with, well, I just want to write it in. You didn't say the same thing as you did tonight.
You talking, I didn't say the same thing?
Do you remember?
No, I don't.
Well, you gave me the rundown on how to do it through footnote and said how easy it was. Well, it really wasn't that easy. And I never sent that affidavit, and I resented that. And I've stumbled since then. So I wish I would have been more forthright. And I'll take that as a lesson. Thank you very much.
Yeah, I don't remember that particular case, but
so it wasn't a question. It was just like, I was glad to see you wanted to do that too.
So your affidavits, Glenn, are of the criminal complaint are included in what you just uploaded in your Telegram under Glenn Fern group?
No. Just the documents that I filed, the Word file for the certiorari. It doesn't include the Word file for this that I filed for this for that motion to demand to disqualify the judge. The Word files for that are not there. The Word files for the criminal complaints are not there. Yeah, there's way too many Word files for all that stuff. It's just, this is the only thing that I uploaded was the Word files for the petition for writ of certiorari, and that is all. But there's like 8 files.
Do you think you could find the time to send it to me by DM? I'd like to, because I'm doing one myself, and I just want to review yours and see if I could use any of your details in mine.
Well, any criminal complaint is like telling a story. And what state are you in?
I'm in Alabama right now, but I'm going to be living in Texas anyways. But the criminal complaints I have are really the same as your. I noticed that we had a lot of the same criminal list of complaints. I was just seeing how you framed yours versus mine. That's all. I just want to do a compare and contrast.
Yeah, well, if you send me an email, I can email you some Word files. But
What's your email?
They're quite lengthy. You know, they're like, some of them are like 18, 20 pages sometimes. And the engineerwin@gmail.com.
Okay, I think I've emailed you before, but I'll email you at that now.
Anyways, the Word files get to be quite lengthy, and it's telling a story, and so it's some of it is not necessarily relevant in every case, but anyways. So this is the clerk's letter that basically denying me due process of law because they have me down as a vexatious litigant. And so there was 4 pages of that. And I just put in a page number at the bottom of the page. And then this is the findings, conclusions, recommendations. That's like 20 pages. So I really don't want to go. We'll skip through all of that. And then the next one is the notice of objection. And that's mine that I filed. That's 36 to 142. So there's 107 pages on that one. And so this I filed into federal court.
That was back in October last year, or no, September.
February, 19th of February, 2025. And so, and this is the certificate of service. And then that one was so long that I had to have, when you, under their rules, if you have if it's more than 20 pages, I think it's more than 20 pages, you have to put in a table of contents and have a table of authorities. And that was definitely more than 20 pages. And so I had to add all that stuff in there. And so that's again, that's what all this is, a table of authorities. But that's not included. But it's buyer's fake judgment, denials of due process of law. Anyways, I went through everything. Building, again, everything is you're creating appealable issues, okay? When you're in these courts, they're not your friend. They're not gonna rule in your favor. You got to build a case for the appeal. And so that's what I was doing.
But hey, Glenn, you know as well as I do, them appellate court judges, they cover the ass of those fucking district court judges a lot of times too.
To some extent, they do. But at any rate, if you don't bring up the right issues and haven't laid a foundation, then you're definitely going to lose. And that's why I just went ahead and did the Rule 11 petition. That's an emergency petition, basically, because it says in the Supreme Court rules that you can use a Rule 11 petition to the Supreme Court anytime, and that it's in the Court of Appeals. Otherwise, there's other times when you can do it, but it's in the court. Mine is in the Court of Appeals, and currently, and so I can go ahead and file a Rule 11 petition to the Supreme Court, and that's what I'm doing. And the reason I'm doing that is because this is something that affects a lot of people, like just about everybody, and it's a violation of the First Amendment. And so it needs to be answered, to help a lot of people. Anyways,
but it's not just a violation of the First Amendment; it's also a violation of the Fifth Amendment, the Due Process Clause.
Well, it's way more than that. It's a bill of attainder. It's all sorts of stuff. So, but the First Amendment, the issue is that there's a lot of the argument. The easiest one to make is the First Amendment because it's the Vatican, and I can show that it's the Vatican. That's the easiest one. And then the more difficult ones are the Bill of Attainder, and that's one of the things I say is that it's a Bill of Attainder, and here's why it's a Bill of Attainder, and it's a denial of the Fifth Amendment, it's a denial of all sorts of stuff. But anyways, the easiest one, all you need is one issue that they hit on, and the First Amendment's the absolute easiest one to go for because there's all sorts of case law that talks about that the government can't be associated with religion, and so and this is clearly the Vatican. So, anyways, this actual document was how many pages? It was 28. It was limited to 30 pages, if I remember right, and I had it at 29 pages. And so when you're in the district court, and so then there was an appendix, and I had an affidavit of citizenship, and I had a bunch of stuff that I'd put in here, and it totaled 107 pages. So I'm just going to breeze through this. See, there's pedigree charts. Get a load of this right here. John R. Jack Winningham was my third great uncle, I think. Third great grandfather. Anyways, his father. Oh no. His father was John Alston Winningham. His wife was Evelyn Gray. And anyways, right here is Henry Livingston. John R. Jack Winningham, his wife was one of his wife was Evelyn Gray, the other one was Permelia Mayfield. And they were she was born in 1818. Anyways, her Henry Livingston, William Todd Livingston, was born in this is my fifth great grandfather, and there is a Will Livingston that was a governor of New Jersey, and that was his son. Henry Livingston and Will Livingston were brothers. And it was Will Livingston was the governor of New Jersey, and he also ratified the Constitution for New Jersey. And so that's what I'm saying is that Will Livingston's my fourth great uncle. Anyways, for what that's worth. And this is the Catherine Phillips notice and demand that I talk about up to the very front. Anyways, and this is the deed. Now, there's defects in this for sure, but it says a living man on the soil of Texas. Fails to be a U.S. citizen, Sesticate Trust. And this is the that General Form 50-141. The chief appraiser may require rendition that's not mandated by the tax code. So they can go ahead and that's forced rendition.
Have you thought about putting a disclaimer as a trustee, implied, express, or constructive trustee?
Why would I do that? Are you saying, I'm saying this whole thing is a fraud, and if you participate in a fraud, you can't claim fraud. So why would I do that?
Well, if you're doing a disclaimer, you're saying that you're not participating in the fraud.
I'm not interested.
You're not an express.
No, I don't want to get into it with you, but I am not. I don't want nothing to do with that trust. If you don't have clean hands, then they will just refuse to give you a remedy because you don't have clean hands. You're participating in that fraud. And so you got to be careful about that. This is that kangaroo court judgment. And then what happened is I sent them a challenge to jurisdiction. And what happened is they refused to accept it. They didn't go and get it. Look at that. I sent it to the Post Office Box 167, which is the address they have on their website. But it was returned, unclaimed. And that was a challenge to jurisdiction. There's the Montague County website. And it's Post Office Box 167. Damn.
What type of jurisdiction? Subject matter, territorial, or personam?
I'm not going to get into that argument today.
Okay, I was just curious.
We need to so they sent me a letter saying that there was, and this is another thing, is they assaulted me with this liar, and then they forced me to pay his attorney's fees. So it's a star chamber. Anyways, that's the entire document right there. So then there was an order accepting the findings and conclusions, which is right here. And then there was a final judgment, which is right here. And then there was a notice of appeal. This is what I filed, a notice of appeal. And then there was a notice of constitutional challenge that I filed. And then the brief support of the notice of constitutional challenge. I'm challenging the minor estate. All of this is uploaded. I uploaded this whole file to the group. Matter of fact, let's look here. Yeah, it's finished uploading too. So it's up there. Anyways, so that was the notice of constitutional challenge, the mandatory judicial notice of 12 presumptions. And this was a certified copy that I filed into there of that. And this was 23 pages. So I'm numbering each page as part of the exhibits. Okay, this is in the appendix. Each of these pages, these items, I'm giving them separate page numbers, and I'm putting that on the that's on the index, or on the table of authorities, or the table of contents up at the very beginning, and also on the page in front of the particular item. Pages 159 to 181. So this one is, and you're welcome to go back and look at this stuff and read it. And if you send me an email, I'll send you the Word files. So this is showing the Vatican now owns and operates the bankrupt 1871 corporation, as evidenced by the Roman Achaea military staff that's planted on all conquered nations, that's sitting on the right side of the speaker's podium. Yeah, so I go through all of that, and I'm bringing that up a bunch of times. And then there's the affidavit of life. It's the next one.
I don't remember you telling me about you having to pay the attorney fees. How expensive was that?
Oh, it was $250. It was nothing, but I didn't like doing it. It just shows that they're a star chamber. It was $250. He was there
I
to.
thought you just paid the tax, the back tax.
Sorry,
I thought you just paid the back tax or the
I did. They
taxes
added
they
it
said
into
you
all
owed.
those. They added it into. I paid. It was $2,200 that I had to pay to get to, so they didn't steal my land. That's why, I can tell you that these lawyers are going to have to hire an attorney, a law firm that is licensed to practice before the Supreme Court. I don't know if you know that or not, but they're going to have to hire a law firm that goes before the Supreme Court, and not every law firm goes before the Supreme Court. And they're going to have to hire a law firm that goes before the Supreme Court. And you know what they say? I went there. Right now, it's some time and effort. All it took was for me to go to the Supreme Court. But they say that if you have to hire a lawyer, that it costs $2 million. And so, no matter what happens with my case, if they rule against me or whatever happens, it really doesn't matter. They're going to have to come up with $2 million to go to the Supreme Court and answer this now. So this is the affidavit of life. That I filed, and then now that it's filed in the federal court, it's easy to bring into any other case in the federal court. And I also filed a notice of void judgment. And this is 49 pages because I attached that Catherine Phillips notice and demand to it.
Oh, you like her.
Yeah. She's taken my name in vain, I guarantee you. Therefore, fake judge Hal R. Ray and conspiracy of fake judge Reed O'Connor engaged in fraud upon the court, in conspiracy of the Vatican's private bar guild members working for the Vatican's County of Montague Corporation when they issued a bill of pains and penalties against me, the named individual, because they intend to be accomplices to the theft of my land by using their Vatican-owned and operated fiction of law. The Texas tax code originated. Yeah, I just rail on them in here, I'm telling you. BAR is an acronym, stands for British Accredited Regency, because all private bar guild members are appointed by Inns of Court. Fake magistrate judge Hal R. Ray and fake judge Reed O'Connor are both private bar guild members as required by the Vatican Civil Laws of Congress, called the Code of Law for the District of Columbia, now known as Title 28, U.S. Code Section 631. The Pope's owned and operated dependent city of London, called the Crown, created the Cestui Que Vie Act of 1666, which precipitated the War of Independence, as evidenced by the causes and necessities for taking up arms issued by the Continental Congress in 1775, and the organic law of the Declaration of Independence shows it was listed as reasons for Declaration of Independence from the Pope's owned and operated tyrant, the Crown of England. Because when they say he's combined with others who subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, he is talking about the Pope's canon Roman law, which is also why millions of people were fleeing Europe at that time, because of the Pope's tyranny there. With the Spanish Inquisition and other inquisitions and oppressions. Anyways. Let's see if I have... King George signed the definitive Treaty of Peace of 1783. Let's see if it's in here. That's in the that's in the actual petition. So I don't have it in that.
It was the
Notice
same
of
one that
judgment.
was signed
What's that?
with only a couple. It was the same one that Queen Elizabeth signed, only with a couple words that were different. I read it last year when he signed it.
The definitive Treaty of Peace of 1783 is not signed by Queen Elizabeth. I don't know what you're talking about, but that was in 1783. It was King George that signed it. And he said in there that he was Arch-Treasurer and Prince Elector of the Holy Roman Empire, which is basically saying that he's got the Pope's approval. Fake Judge Hal R. Ray and fake Judge Reed O'Connor are tyrants operating as bought and paid for administrative clerks masquerading as judges under the Pope's canon Roman law and bad behavior and fraud upon the court, which are non-judicial proceedings because whenever a statute's involved, the Pope's fake judge is actually a bought and paid for clerk masquerading as a judge. Which means they're legislators engaging in legislative acts against me, the named individual, which is a bill of attainder or bill of pains and penalties, which are prohibited under Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1, and also Article 1, an amendment, which says Congress shall make no law respecting an establishment of religion, because it's from the Pope's Roman law, also known as canon law, and because they've imposed martial law rule, which is why we took up arms in 1775. And this is all attached to that petition to the Supreme Court. Now, whether they're going to go through and read this stuff, I mean, it's in the actual petition itself, and they can go through and, anyways, we'll see.
It's action-packed. John Patrice has a question, Glenn.
Sorry?
John in the chat has a question. Do you want to take a question?
Okay, yeah, sure.
Go ahead, John.
John, I'm not seeing John.
Oh, okay. I hear you now. Are you there? Thank you, Glenn. Thank you, Lay. Can anyone hear me?
I can hear you. What's up?
Okay, it's actually 3 questions in one. What is the government shut down to? Did the shutdown affect the case you're being heard or the mail? That's static. If there is a shutdown of the government, would that have any effect on the mail being delivered or the case being heard by the judicature? And does shutdown equal takeover?
I don't think so. I think that there's certain parts of the government, like the military. The military's still there. They were actually working on there was an article I read recently about that they had a bill that was trying to get funding or pay for the military, had failed in the Senate, and so what'll happen is they might miss a paycheck, but they'll get back pay, and so they can't really stop a lot of the government. There'll be unnecessary parts of the government that's going to shut down, and Trump wanted to get rid of a lot of these bureaucrats, and now I think he's using it to do that. So some of it's going to go away, but the courts will still operate normally, and so some parts of it, like the military's all going to operate normally. I don't know how it's going to affect the FBI. If it does affect the FBI, I have no idea. But some of them might not get paid for, they might be missing a paycheck or something like that. It's hard to say how that's all going to work out.
Good question, John, because I've been hearing that Trump can't afford to pay the military.
Yeah, I don't know how that's all. I know that you know, the military can't just stand down just because they don't get paid. You know, um, they have a term. That's why they're on salary, because they get they have a period of time when they have to serve, and they'll get back pay. You know, so whenever it all gets straightened away, that there'll be back pay, and all the rest of it. A lot of this is the Democrats. You know, the communists are trying to obstruct, you know, the government, and
the propaganda wheel. Yeah, the propaganda wheel.
Right. So this is the Catherine Phillips notice and demand that was attached to the notice of void judgment. And then there's, after this, is the affidavit. This is the common law court case that we did. And this is what I'm curious to see what the what they have to say about this. Because under the Seventh Amendment, they cannot review a common law court case except by the rules of common law. And none of the courts operate under common law. So we'll see what happens. I'm curious. They like to pretend it doesn't exist, but
do they have 21 days to answer or 30 days?
For what? To answer this common law court judgment?
Yes, to answer it. Yes.
It's they can't answer it because they cannot answer under common law. They don't operate under common law. They're all military courts. That's why they can't answer it. And so so they have nothing to say. Common law is superior to them. And so that's why I want to see what the reaction is. There's other courts that I've seen with common law judgments. When common law judgments were involved, all they do is they say they recognize it. You see what I'm saying? And that's all they can do is recognize it, because they cannot say that, you know, this is a bad judgment or something like that. They cannot dispute it at all. It's superior to them. And so they got nothing to say about it. That's why I wanted to get it in there.
So you won't have to do like an ownership of your land claim again or anything.
Well, this common law court judgment is for is basically saying that Montague County is a bunch of thieves, and they owe me $1 billion. And so let's see what they say. If it goes down to the very end. And the lawyers, they're all engaged in barratry. And the lawyers should get disbarred, all of them. It says here, Patricia Coleman Byers and Patrick Jack McGaughy are operating at administrative court, is working for the executive branch, are filed into the case, failed to perform his ministerial duty to issue warrants as required. Evidence is prejudgment, and the demand is sworn and was sworn in shortly after. They're in bad behavior and cease to be a judge in this matter and have waived their immunity. Are tyrants. cannot do anything judicial like issue orders, convictions, or judgments. Their judgment is a fraud. Deprive themselves of subject matter jurisdiction. All their orders of judgment are void and an absolute nullity, and a brutum fulmen. And I can attack a void judgment at any time, directly or collaterally. Wrongdoers have ceased to represent the government or waived any immunity. Wrongdoers are individually violating my right to be let alone under color of law. Violation of 18 U.S.C. 242. Wrongdoers engaged in official oppression, conspired to threaten, coerce, injure, intimidate me in a free exercise of my rights, 18 U.S.C. 241, are subjecting me to their satanic religious ceremony, which is a violation of 18 U.S.C. 247, right here. Tampering with my rights under a land patent, making false entries in government records, 18 U.S.C. 2073, that's 10 years in jail, by the way. Subjecting me to peonage, conspiring together to use the Commerce Clause to bring the District of Columbia outside not exceeding 10 miles square. They can't argue against this unless they can come up with a common law, but they can't. They don't. They don't do anything under common law. Enticement into slavery, engaged in mail fraud, simulating a legal process, failed to provide a bona fide contract, sending threats through the mail. I mean, there's multiple felonies that they're involved in. Anyways, so we'll see what happens. They're a criminal racketeering enterprise. Honest services fraud. Engaged in war crimes. They owe me 1 billion silver eagles. The price of silver, that's $50 billion right now. That judgment is vacated and declared a fraud and a nullity. These lawyers are ordered disbarred for barratry. This finding of facts and conclusions by the jury is not reviewable by any other court in the United States except as set forth under the 7th Amendment, nor is subject to trespass upon this case by the judicial power of the United States. See the 11th Amendment of our national Constitution. Anyways, so I'm curious to see what they say about this common law court judgment.
How many judges are going to be ruling on it?
Sorry?
Well, the Supreme Court here is 3 judges.
No,
how many judges will there be?
There's 9 judges on the Supreme Court. And what they'll do is they have the opportunity to, they can turn any case away they want. But I'm telling them in here that I am posterity, and so they have no right to turn the case away. And they have no right to tax me. I don't say that in this one. We'll see what happens. I haven't. Oh, that reminds me. Let me clerk's letter. This is the clerk's letter that I put in there. So says, please find enclosed 10 copies of a petition for writ of certiorari in boxes 1 and 2 filed pursuant to your Rule 11, because this is bringing up nationally important issues of the constitutionality of the Pope's 1871 municipal corporation operating in the District of Columbia, the Pope's minor estate, now codified at 31 CFR 363.6, and the Pope's private bar guild, all of which affect nearly everyone in this country. I see your rules require an impecuniosity interrogatory, and I'll be very happy to complete it when you provide your statutory and delegated authority to require me to complete it, as well as an Article 4 and Amendment warrant describing what exactly needs to be disclosed, signed by an Article 3 judge acting in his official capacity. If you want to email me at engineerwin@yahoo.com, I can email or WeTransfer you a PDF file of this petition. If there's anything I overlooked, please advise. I appreciate your help in this matter. And so this is the letter that I sent, the cover letter. So there's 2 boxes. I was 2 flat rate boxes I sent. And so we'll see what happens. So this is the cover letter, and then there's a certificate of service. So we'll see what they say.
We had another question from Dan, but I didn't want to interrupt you, but he might come back again.
Sorry?
We had a question from Dan, and now he's left because I don't think I didn't want to interrupt you.
Yeah,
we
that's
might
fine.
come back.
Well, he asked a bunch of questions already, and then he was starting to interrupt things and all sorts of stuff. So, I muted him.
Yeah,
Actually.
I was gonna tell him that we're not gonna discuss that subject at the moment.
I muted him because he kept interrupting. Anyways, so that is the. Let's see what's on YouTube.
Well, they got a lot to answer too. It's a loaded gun.
Sorry?
It's a loaded gun. They've got a lot to answer to.
Well, that's true. Somebody's talking about the Trump accounts.
What about them?
I don't know. Oh, they're talking about, I guess it's a new Cesta KV. I guess. I don't know. I don't think, I don't want anything to do with them. Oh, that's
what, for the new arrivals or something, or what?
Sorry? They're talking about Trump accounts.
An offer to the new arrivals? Or?
I guess. Well, it's some sort of retirement program that they're putting together for kids. I don't want anything to do with them. It's a recipe for what's going on right now. Anyways, so we've been going on for over an hour. Is there anything else we want to cover, or should we wrap it up?
Well, you kind of clarified everything that you've put into the case, and now that it's filed, I want to know, does it give you some relief?
Well, not really, not yet. In the past, I've been to the Supreme Court. This is number 6. In the past, what would happen is the Supreme Court, I'd have a cover letter. They'd want me to fill out an impecuniosity form. And so I would have a cover letter, and it was an affidavit, and it'd tell them that you have no right to tax me because I'm one of the people, and you have no right to turn this case away. And they would accept it every time. And there'd be no filing fee. But so what we did this time is you see the cover letter I had, it was different. And so we'll see what happens with it. But this is a Rule 11 petition. This is an emergency petition. I never did this before. We'll see what happens.
Yeah, that was interesting. They do that when it's currently in appeal. That was interesting. I never heard that before.
Yeah, that's true. That's in their rules. Well, I got the idea from the Brunsons, actually, because they did a Rule 11 petition. And so we'll see what happens. So what I am doing is I think this is going to be something they want, okay, because of the fact that I'm bringing up the First Amendment, that this minor estate is a violation of the First Amendment. That's easy to prove. And now whether that goes to the 1871 corporation, it's hard to say. I think it does, but whether they're convinced it does or not is yet to be seen. And then the bar, right? I think the minor estate is clearly the Vatican, and I think that I'll win just on that. We'll see what they say. So I think this is the kind of case they want. I think that they'll accept it, and we'll see what they do. Whether they, I tell them that I'll be glad to fill out their impecuniosity interrogatory when they provide their statutory. There is no statutory and delegated authority, and there's going to be no search warrant. I guarantee you. And so, I don't think they're going to go there. So we'll see. That's all I can say. I wouldn't be surprised if it comes back, with a letter from the clerk saying that, well, I didn't do this and I didn't do that, or something like this. We'll see. They could also get a letter saying a docketing letter. Okay. The other choice is, because in the other ones, I eventually got a docketing letter from the Supreme Court. And it's a letter. It's a 1-page letter. It says your case has been docketed. This is the case number, and send this letter, a copy of this letter, to all the respondents. And so they could send me a docketing letter, and then I'd have to send a copy of that letter to all the respondents, and they will then they'll know that they have to respond. And then what would happen in the past with the other cases is they'd waive their right to respond. And I don't think they can in this case, because I'm challenging the constitutionality of the minor estate, and I think that they're screwed now, because they cannot just blow it off like they did in my other cases, and so they're going to have to. They're going to have to answer. And so we'll see what they say. That's all you can do,
Is the docket number the same? Would be like the trial date set, or would there be another time after that a date would be set where it would be constitutionally heard. Right?
Well, first of all, there's oral arguments, and I can tell you right now that they won't ask me to come and make oral arguments. Okay, I'm not a lawyer. Only lawyers can go and make oral arguments. And so I doubt there'll be any oral arguments. I think that what they'll do is they'll send me a docketing letter, and then I'll send that out, and then all of the other lawyers will have to respond, and they'll respond, and I think it'll be decided without oral arguments. I'll bet you. Because I'm not going to go to the Supreme Court and make oral arguments. I'm not a lawyer. They're not going to ask me to. I guarantee you. I've seen stuff recently where they'd say that only lawyers can come and make oral arguments, and so we'll see. I'd be very, very shocked if they wanted me to come and make oral arguments.
Interesting. So you won't tell me who told you about that website that you said CSIS uses to profile that targeting
targetedjustice.com. Yeah, I don't know where I got that from. I mean, people send stuff to me all the time.
But you haven't used that in any of your other stuff, I don't think, have you?
Well, I've used it. Yeah, I've used it in because that's what they're doing. They're targeting me, basically. They're taking reprisals. That's called war crimes, is what it is. So we'll see what happens, And so,
Yeah.
What's that?
Go ahead.
I was just going to ask you, like that little hiccup you had in New Mexico or wherever it was, did that motivate you or make you stronger, or hold you back? Like, did it put you back behind schedule, or did it speed you up? That little mishap.
Well, that's a good question. What happened is I was trying to get the Republic of Texas to do a declaration of peace, and they don't want to, and so they have no vision, in my opinion, and so I have resigned from the Republic of Texas as a senator. I've resigned, and they can go ahead and do whatever they want to do. I'm going to have to sue them. Is what's going to have to happen. But it did motivate me. I was hoping that this they'd do a declaration of peace, and so then that would help my situation. But so now I'm going to have to sue them. Is what's going to have to happen. And so we'll see what happens with this Supreme Court case. That's all I can say.
That's unfortunately, they didn't approve it, or what was it up to? Like, how many different senators were supposed to be agreeing to do the declaration?
Well, it wasn't, it was, there's, it's a long story. It's internal politics, really. And so they just don't want to do it. That's all there is to it. So, anyways, if they're not, I told them that I'm not fucking, I'm tired of going to jail for the Republic of Texas, so that's why I resigned, and they can, go and do whatever they want to do by themselves. They don't need me. And if they do think they need me, they don't need me that bad, obviously, because they're not willing to do anything for me. So they can just do it themselves, So anyways, I think we should wrap it up. It's we've been going for just about an hour and a half. If there's nothing else, I think we'll just wrap it up and call it a night.
We have another question. From E.
From who?
E. From E is in the chat.
Okay.
Go ahead, E. You can unmute yourself. Go ahead. Okay, I unmuted them. Maybe they hit it by mistake or something.
Okay. All right.
Oh, okay.
I came in late on the chat. Is this the continuation? Your letters going to the Supreme Court for land that they took away from you? Is this part of it?
They didn't. They tried to steal it. It's theft, and so there's. I'm calling it theft. It's over taxes. If you had to pay a penny, then they can take it all. And I'm not in the District of Columbia, and it's theft is what it is. And either I own the land or I don't.
Okay. Well, all right. I was trying to keep up with everything, but I was trying to get my property back. So,
well, that's another reason why I have to fight this battle, because I understand it better than most, and it'll help other people too.
Well, what happened to me was that I did something at the last minute, and so I stopped the district court from issuing a writ of possession, but they went under the table anyway and sold my property. And they all trespassed on the property, and that's at the point where I'm at now.
Here you go.
I had to go after them.
And they're a conference
find
still.
them.
So they won't wake everybody up. You gonna play?
I'm on here.
Oh. Okay, well, that's what happened to me. They took it away, booted me on the street, but they didn't have anything from no writ of any kind from the district court ordering me off the property.
So what state are you in?
Texas.
Okay. Yeah, Texas is really bad. And so they need to put a stop to this. There's other people I know in Texas that are having similar problems. That's the reason I have to fight this. And the Texas is really bad.
Yeah. I will be going to court to confront them. My name is still on the property. They can't sell it unless I agree to it. I did something at the last minute, so they couldn't take my equity in the property, and nobody would listen to me. So we're finding out there was a group of people, they've done this before to other people. They go ahead and sell their property, steal it from them under the table. So.
Well, keep at it. That's all I can say. And file criminal complaints. I did all sorts of shit. You see what's in this petition. That's the reason I put all that stuff in this petition. Because it lets them know that I just didn't roll over, and that I fought it claw and nail, and so hopefully they intervene. You know what I mean? We'll see. Okay. That's all I can say.
Okay, I had to get the FBI to go find these constables. They were paid by someone to do this. They took money for it, and. That's where I'm at right now. We found them.
Well, that's all kind of part of that big bad game that we were all talking about earlier.
Yeah.
So Glenn, I don't want to keep you any longer if you don't, if you have something other to do, or I don't know, usually your mark is about 2 hours. So you've been really gracious with your time, and I just want to thank you for showing us, and I'm really excited for the fact that you got it sent out.
I appreciate it. It's not over. There's a lot of things that can still happen. I'll keep you guys posted about what happens, and progress. And so we'll meet next week. I may not hear anything by then, but I might. You never know. We'll see what happens. And so this is number 6, 6th time to the Supreme Court. Every other time, I got docketing letters, and then they waived their right to respond. I don't think they can waive their right to respond this time. So we'll see. If I get a docketing letter, then we'll see. That's all I can say. Every other time I got docketing letters, and then they waived their right to respond. But they can't waive their right to respond on this one. I think this is a case where the Supreme Court actually wants this kind of case. And so we'll see. Thanks for everything, and we'll see you guys next week.
Same time, same place.
You bet.
Okay, take care. I'll talk to you. Bye now.
See ya. Bye.